Tammy Gunderson is the first representative. This is the fifth case that has come up before this court this year concerning enforcement of settlement agreements in workers' compensation cases.
Would you try to speak into the microphone or raise it a little bit? I'm having a little trouble hearing.
Oh, I'm sorry. This is the fifth case that has come up to this court this year concerning enforcement of settlement agreements in workers' compensation cases. There are actually four previous ones: Calderon versus JB Nurseries, Godino versus Oasis Outsourcing, Quinlan versus Ross Stores, and Hale versus Shear.
Okay, let me ask you a question. Am I correct that there's nothing on the record indicating that the insurance company objected to the form of the release that the personal representative was willing to sign?
In fact, we prepared a general release, and we submitted the general release on our own to the employer carrier. Our position is, obviously, that the judge, when she considered this settlement agreement, should not have gone into the general release and the waiver and the resignation because it's beyond her jurisdiction. But out of an abundance of caution, we went ahead and drafted one and sent it to the employer carrier. The employer carrier never objected to it. They never asked us to prepare something different. We realized in the Calderon decision that the judge did go into whether or not an employee would execute a general release, a resignation, and a waiver. That case, it sort of mirrors our case. It's the reverse of it. The employee in Calderon entered into a settlement agreement at mediation, agreed to sign a general release, a waiver, and a resignation, and then the employee reneged. In that case, the employer carrier went to court, and the employer carrier said, we want to enforce this settlement agreement in comp, even if the employee doesn't want to execute a general release and a waiver and execute a resignation. The court in Calderon said, yes, it's enforceable. It's voidable at the election of the employer carrier. If they want to go ahead and move forward and settle this case, even though the employee won't sign a general release, then it'll be enforced. In this case, it's sort of the reverse. The employee insisted that we move forward and settle this case, at least the personal representative of the employee did, and went through all of the steps it needed to be gone through. This settlement required that there be an approval of the attorney's fees, which occurred.
Unless I'm wrong, in Calderon, the language also said that the form of the release would be drafted by the employer. In that case, we don't even have that language in this case, do we?
In this case, the language specifically said that the claimant agrees to execute a general release and voluntary resignation. General releases will not affect vested pension or defined compensation rights. The employee went ahead and drafted that and submitted it to the employer carrier, which they accepted and which was placed into the record. At hearing, in this case, which we pointed out to the court, here is the general release. We've submitted it. It's pretty clear that when you look at the settlement agreement, it doesn't say that the employer carrier has to draft it. It doesn't say that the employee couldn't draft it, and we did. We got the order approved as it related to the attorney's fees. And one important distinction that we have in this case is that all three of the earlier cases, Calderon, Godino, and Quinlan, are interesting because when you read those decisions, you can determine from those decisions that the judge actually took evidence. She took testimony, or he took testimony from both sides as to what their subjective intent was and as to what they thought was ambiguity. This case comes to this court for de novo review. It's a matter of law. Did we or did we not have a contract? In this case, it's real clear. There was an offer, there was an acceptance, and there was consideration. And this case in the settlement agreement was sufficiently specific as to what the essential terms were.
And if I read your brief correctly, you're arguing that as a matter of law, that the personal representative has the right to complete the execution of an executory contract by signing the general release and the resignation by virtue of 733-612.
Exactly. That was one of the points I wanted to get to. There was nothing in the settlement agreement that stated that the attorney's fees had to be approved during the life of the claimant. There was nothing in the settlement agreement that said that the employee, specifically during his lifetime, would have to execute a general release or resignation. Clearly, the statute, 733, provides that the personal representative certainly has the power to do that. Specifically, they have the power to execute contracts, they have the power to negotiate contracts, and they have the power to resolve disputes on behalf of the estate. So our position is clearly that everything that needed to be done, that possibly could be done by this estate, was done. And the judge, notwithstanding our arguments, seemed to reach the conclusion that the execution of the general release and the resignation was somehow a contingency to the contract, which we obviously
But even if it was, the judge didn't address whether or not the personal representative's performance of that contingency satisfied the agreement. That didn't appear to be addressed by the JCC.
Well, only to the extent that she puts in her order the claim did not meet these contingencies, referring to the general release and resignation prior to his death. Thus, in the strictest sense, it may be concluded that the contingencies were not met and an enforceable contract for the purpose of settlement was never finalized. That was her finding.
So the JCC read a provision, in effect, into the settlement agreement that said it had to be performed by prior to the death of the claimant.
That is certainly our position, that the judge tried to read something more than what was clear from the four corners of the document. And that's why we say the earlier decisions of this court, this court will grant deference to JCC where there's disputed evidence and there's vagueness and ambiguity. The court makes that call. The JCC weighs that evidence, and this court generally will say, okay, we agree with that, unless there's an absence of competent and substantial evidence. But in this case, it's a question of law. And it really gets back to Contracts 101, offer, acceptance, consideration, very clear terms, what had to be done in every instance.
Okay, you're down to 2.5 minutes.
Okay. Thank you. I'll reserve the rest of my time.
May it please the Court, I'm Gray Sanders here on behalf of the appellees, the Hillsborough County School Board, and Broadspire. We ask the Court to affirm the order under review based upon two reasons. First, the order is supported by competent and substantial evidence as set forth in the judge's order. And secondly...
There are no factual disputes here, are there? I mean, they submitted a release. You didn't object to the release. The personal representative was going to sign. So we're not even talking about a competent substantial evidence. I mean, nobody's disputing any facts, are they?
There is the factual issue, Judge, is that the judge below determined as a finding of fact that it had been an essential term of the settlement that the school board was to receive.
Is that a question of law or a question of fact? If the contract is unambiguous, doesn't that become a question of law?
I do agree with the appellant's statement that this court has addressed the issue 4 times on enforcement of settlements in a workers' compensation case. And I believe in those 4 cases, this court has set forth the following analysis. You will defer to the judge in determining whether or not certain items were essential aspects or essential terms or express contingencies of settlement.
Okay, let's assume for a second that execution of a release was an essential term of this contract. I mean, I don't even think the other side's really arguing with that. Why can't the personal representative execute the release pursuant to 733.612?
I don't know, Judge, and the record doesn't reveal. The JCC below did not go...
Well, that's not a good enough answer here.
But she was not asked.
If the statute says the personal representative can execute a contract, then you need to tell me why that statute is inapplicable.
Because under the freedom to contract, when the parties settle the case, that's the beauty of the settlement. The parties have the power within their discretion to create whatever sort of agreement they desire to settle the case. For reasons unrevealed in the record, it was crucial to the school board that it obtain a settlement executed by the appellant, Mr. Gunderson.
Help me here. The reason you want to obtain a release, well, first of all, you don't want him to come back to work. That's obvious. And he's not coming back to work. So that part of the contract is taken care of. So the only thing we're talking about here is a release. Can anybody other than the personal representative bring a suit on behalf of this person?
I do not know, Judge. And that was not addressed.
Again, that's not a good enough answer, because you need to know the law. We're not talking about, can anyone bring suit on behalf of this employee other than the personal representative?
Likely not, Your Honor. We
Okay,
can see that.
so if a personal representative is authorized by statute to execute a release, and that is the only person that can bring the statute, why have not all the conditions been met of this contract?
Two factors, Your Honor. First, the time delay. This court set forth clearly in Calderon that if there is a failure to satisfy, a contract becomes voidable. The school board had notified the claimant that upon the claimant's death 12 days after mediation, it considered that to be a voidable contract and was withdrawing from the contract. It was 4 months.
Well, no, wait a second. Did they have the unilateral right to withdraw from a binding contract?
Your Honor, that's the issue. The mediation agreement was not itself a binding contract. It was an agreement for conditions precedent that additional agreements would be made. Additional documents would be created.
I have the wording of that in front of me. Show me where it contemplates anything other than the order approving motion for attorney's fees occurring first.
There are 3 paragraphs to the mediation agreement. The second paragraph specifically addresses that the claimant, not anyone on the claimant's behalf, will execute a general release and a voluntary resignation. Then the third paragraph in the mediation agreement specifically states that the mediation will not be binding or effective until entry of an order approved by the JCC for the motion for approval of attorney's fees.
After the motion for attorney's fees was approved, could the employee, if he was still alive, have walked away from this contract?
I'm sorry, Your Honor.
If, after the attorney's fees were approved, could the employee, if he was still alive, have walked away from this contract?
Well, when you say this contract, Judge, I think based upon the Calderon decision, the claimant, after the mediation, after the order approving attorney's fees, could have refused to sign the release. The claimant could have said, despite what I agreed to on November 7th, I will not execute a general release.
But didn't Calderon also say that the employer could have enforced that contract?
No, Your Honor. Calderon says that the employer could have then enforced the workers' compensation part of the settlement, or could have withdrawn from the settlement in its entirety at its election as the non-breaching party. That's the proposition Calderon stands for.
At the election, which assumes it's the non-breaching party.
Yes, Your Honor.
So the employee, by walking away in Calderon, breached the contract.
Yes, Your Honor.
So there was a binding contract in Calderon, was there not?
There was an agreement with, quote, in the language of this term, there was an agreement with express contingencies. The express contingencies requiring a general release and a voluntary resignation. If the claimant failed or refused to execute either of those, this court has said that the mediation agreement becomes voidable at the election of the other party.
But that didn't happen. You had a personal representative who steps into the shoes of the claimant, who signed and satisfied all the conditions that your client specified and would have gotten it but for the unfortunate event. Right?
Judge Browning, which is exactly the situation that was addressed by this court in the Quinlan case, Quinlan versus Ross. Almost factually identical situation where a claimant dies after mediation and the estate signs the necessary documents and proffers them to the employer carrier. The employer carrier stated, the employer carrier's position in Quinlan was that the personal representative signing the documents was not sufficient. And
the language in Quinlan, though, was the mediation settlement agreement was expressly not final and was contingent upon both parties' approval of the Medicare set-aside.
Yes,
so they specifically said in there was no contract until that was done. Show me the language in here that says there was no contract until the release was signed. The paragraph here, what's concerning me, when somebody wanted to make something a condition precedent, they were very clear about making it a condition precedent. They said there's no agreement until the attorney's fee order is approved. Nowhere else does it say that this was not effective and binding or that there were any contingencies prior to this being an enforceable agreement. And I would suggest to you that if the employee tried to walk away from this, you would have said they would breach the contract. So there was an enforceable agreement upon the attorney's fee order being ordered. And it was an enforceable agreement. A contract is enforceable on both sides. Correct?
No, Your Honor, we respectfully disagree. This court has determined that you will defer to the JCC in determining what are the essential terms of settlement. Once the JCC has determined what are the essential terms of settlement, then you will analyze whether they have been fulfilled. In this case, the JCC
let me tell you
determined.
something here, and I'm showing a little bit of my peak, let's say. The JCC referred to this action as being reprehensible. I don't think the JCC was far off. You had a contract, the insurance company, and you're trying to walk away from it. There's nothing in this contract that it was contingent upon the release being signed prior to a contract. And I find it offensive that you can't, that the law, 733-612, specifically says that a personal representative can sign a contract and release, etc., and you can't stand here and offer me one reason why we can't support 733-612. Also, I'm wondering whether this court on its own motion, pursuant to 57041, I believe, should assess attorney's fees not only against the carrier but the law firm for pursuing this.
Your Honor, if I may address that. The sympathies in the case are certainly important. The fact is that the actions of the self-insured school board are entirely consistent with their position that a release signed by the claimant was an essential term. If the court upholds the order of the JCC, the school board does not walk away from a settlement. They are not concluded with this case. They do not get something for nothing, the benefit of a bargain.
Counsel, let's assume we agree with you and the JCC that the release was an essential term. Why hasn't that term been fulfilled by the action of the personal representative?
Because the release and the settlement documents were not drafted by the employer carrier. The employer servicing agent withdrew from the settlement, voided the settlement upon the death of the claimant.
Did you ever raise any objection to the form of the release that was submitted to you?
Your Honor, we objected to, there are two releases here at issue, or two documents submitted to the court. In February, on February 27, 2004, documents drafted by claimant's counsel, which were the motion for approval of attorney's fees, were submitted to the court. They were approved on March 2nd, and the following day, when we received it, the employer immediately objected to those documents on the basis of the fact they had not been drafted by the employer, and the employer had withdrawn from the settlement and said the contingencies can't be fulfilled. The transcript of that hearing is contained in the record, and at the time, counsel for the appellant...
Okay, but I understand you objected and said it could not be, wasn't drafted by us, it was not signed by the person that was contemplated. I understand those objections. Is there anything in the record indicating that your client objected to the form of the release?
No, Your Honor.
Thank you.
Your Honors, one other thing, we had mentioned the fact that we had the enforcement hearing as it related to the mediation agreement. There also was a petition for benefits seeking the penalties and interest and cost and attorney's fees that was at issue that got denied when the court determined there was no settlement agreement, but certainly that's one of the things that we pursue is a reversal and that the court enter an order awarding that. But getting back to the arguments of the employer carrier, I think the Quinlan case certainly is materially different than this case, in addition to what you all have noted, that it wasn't a finalized agreement, there were not some essential terms in it. My reading of the decision, I recall it says that only the employee signed the agreement. The employee signed a document that stated it was simply a draft. The employer carrier never executed any document. So quite clearly, in that case, there was never a meeting of the minds. There was never anything that was sufficiently certain. My recollection of Quinlan is that both sides had the option to look at a MSA number and decide whether they wanted to take it or not. So certainly everybody had options there. That's not the case here today. It's quite clear that this court should review this case as a question of law, When we went to hearing, we submitted the paperwork, and nobody presented any testimony. And we've, quite frankly, said, Judge, it's your call. It's here. It's all on paper. You know, nobody came traipsing in saying, well, that isn't what I meant or that isn't what I thought. That's the common thread that you see in all these earlier decisions, Calderon, Godino, and Quinlan. The only other decision, the Hale versus Scheer, happened to come out of this same venue with this same judge. In reading the decision, you don't know what occurred there, but in getting on DOA's website, you can pull up the compensation order that was appealed, and in that case, no evidence was submitted in the form of testimony. It appears that was purely a documentary thing. So we would reiterate that this is a question of law for this court to review, and we believe that it's a rather straightforward decision that requires this court to reverse the judge of compensation claims and to instruct her to enforce the settlement agreement and to award the penalties, interest, costs, and attorney's fees. Thank you.
Thank you.